This is Bloomberg Law with June Grasso from Bloomberg Radio.
The lawsuits have been called unprecedented. The Trump administration has filed lawsuits against 4 blue states over their lawsuits against fossil fuel companies. The states are trying to collect billions of dollars from oil companies like ExxonMobil, BP, and Chevron to hold them accountable for damages caused by climate change. But last week, the Justice Department sued Hawaii, Michigan, New York, and Vermont, trying to shut down their lawsuits against the fossil fuel companies. My guest is environmental law expert Pat Parenteau, a professor at the Vermont Law and Graduate School. Pat, is it unprecedented or just unusual for an administration to be suing states over their lawsuits against companies?
It's unheard of. There's never been a case where the federal government has filed a lawsuit in federal court to prevent states from bringing their own actions in their own state courts. It's almost like saying, don't you even think about it. So I predict that these cases will be dismissed. There's no legal basis to do this kind of preemptive strike before you've even seen the complaint. Now, Hawaii has sued, so we now know what their complaint looks like. Michigan, the Attorney General there, Dana Nessel, is determined to file suit, but hasn't yet. But, this move is kind of a show of force, shot across the bow sort of move, but it's not going to result in preventing the states from bringing their cases. There's still going to be arguments about whether the cases can move forward or whether they're going to be dismissed, but that's a separate question.
Here's what Attorney General Pam Bondi said. These burdensome and illogically motivated laws and lawsuits threaten American energy independence and our country's economic and national security. So they say they violate the federal government's foreign affairs power. They're preempted by the Clean Air Act. Tell us about what their claims are.
Their claims are groundless. They're fact-free. The United States is the energy dominant force in the world. We're the net exporter of oil and gas. We've got more than adequate reserves to provide for our energy needs as well as to export energy. The problem with that, of course, is that's driving us further into the climate crisis, closer to the climate cliff that climate scientists are warning us about. But the energy is there. It's booming. So there is no crisis. There is no emergency on that front. And in terms of baseless claims, well, that's why we have courts. We'll see. The cases that are proceeding against the oil companies, which the Trump administration now wants to go to bat for, 6 of them filed by different states are moving towards trial. The one in Hawaii that was filed by Honolulu, that's different from the case that the state has just filed. That's in discovery. That's moving to trial and so forth. So, there's a way to determine whether these cases have merit, and it's not in the press, and it's not with a statement from Pam Bondi. It's a decision that will be reached in due course based on the evidence by juries in state courts, and we'll see how that all plays out. It's a long game. We're a long way from knowing exactly what the final result is going to be. But one thing we do know, all of these states that are bringing these actions are suffering enormous costs and damages from the effects of the climate disruption that we're currently seeing, never mind what's coming in the future, right? So in, Vermont, flooding has caused over $1 billion worth of damage in back-to-back flooding events, 2023, 2024, and more to come. So, there's real damages, real costs. And these cases are designed to say very simply, your product, oil companies, caused the damage. You didn't intend it, perhaps. You knew about it. You didn't tell the truth about it. That's what these cases are alleging, of course, and have to prove. But the truth is that the damage has occurred, the costs are being incurred, and the companies that have made very significant profits off of marketing their products and selling their products to people who wanted them, for sure. In our legal tradition, that means the result of your activity, which has caused the states to incur costs, exposes you to liability for recovery of those costs. That's the nature of the cases that are underway.
The federal government's lawsuits also allege that the state's suits are a risk to national security. According to a statement from the Attorney General, Pam Bondi, it makes the U.S. less able to defend itself from hostile foreign actors. The Trump administration is using national security concerns in all kinds of actions, from invoking the Alien Enemies Act up to tariffs on movies made overseas.
And, of course, prior administrations, even as far back as George W. Bush, a Republican administration, of course, the Defense Department has been saying climate change is one of the major threats to national security. It's a force multiplier effect. It causes disruption around the world. It makes us more vulnerable to terrorism, etc. That's the Defense Department speaking. That's not environmental groups. That's not the states that are bringing these actions, creating these threats. These threats are real, and they're the result of these impacts that are causing the climate system to basically go out of control. So, the whole idea that the states seeking recovery of these costs are threatening national security is pure bunkum. It's not true. It's not real. It can't be proven. And the companies have raised various kinds of arguments. Many times the courts that have considered those arguments have rejected them. There's still cases pending. We'll see how they go. But there's a way to make those arguments if you want to make them. But so far they have not won the day.
Hawaii's Attorney General, Ann Lopez, besides calling the lawsuit deeply disturbing, said it was a direct attack on Hawaii's rights as a sovereign state. So states have constitutionally protected rights, but where's the line between the state's rights and the federal government's rights?
Well, it is certainly true that states have limits on what kinds of actions they can bring that affect interstate commerce, for example. And, that's a very complicated area of the law. We had a recent decision from the U.S. Supreme Court that was badly splintered. It involved California's regulation of pork production. And, of course, California being a fifth largest economy in the world, it imports a lot of pork products, particularly from places like North Carolina, which has these massive factory farms, right? And so the latest announcement from the Supreme Court is very fractured, but the essence of it was to uphold California's law regulating the way hogs are raised in North Carolina, okay? So one of the central features of the limits on state authority is you can't unduly burden interstate commerce with the legislation that a state might enact. Even in that case, the Supreme Court upheld basically California's law. The point is, again, there are arguments you can make that states have exceeded their authority by externalizing their law to other states or to the nation. That's something the Trump administration is arguing, that one state can't set rules that govern all states, for example. Okay, I understand that argument. You can make that argument and see how it goes. But you can't say you can't even bring a lawsuit based on a state law because we, the federal government, have determined it's unconstitutional. That's not the way it works. So if the Trump administration wants to intervene in some of these ongoing cases in Vermont and New York, for example, which they now have said they're going to do if they haven't already, fine. Come on in, join the party, make your argument, and see what happens. But they don't enjoy any particularly special authority when they do that. They can't walk into court and say, we're right, just issue an injunction or issue an order according to what we would like to have you do. Again, that's not the way it works. Make your argument, see if you can win it. I don't think they will, but they're entitled to try.
They filed lawsuits against Vermont and New York. And are these based on the Superfund Acts?
Yes, they are. And they are following in the footsteps of the state attorneys general in the Republican states, the red states, 24 of them have filed lawsuits against Vermont and New York. So the Trump administration is a little late to that party as well, but they're joining with their colleagues in the red states to argue that Vermont and New York's climate superfund laws are unconstitutional. Same array of issues you mentioned earlier, that the Clean Air Act preempts these cases. Well, wait a minute. These cases are not about emissions. They're not regulating sources of emissions. They're not regulating power plants. They're regulating the producers of the products, the oil and gas, that are, of course, fueling these power plants and cars and other things. But their arguments are based on Superfund type remedies, which are when you have an indivisible harm, which climate change is, all of these greenhouse gases mix in the atmosphere, and you can't tell, and it doesn't matter where the emissions are coming from. They're all causing, indivisible damage, real costs. And under the polluter pays principle, which is what Superfund is, there's strict liability, not based on fault. It's a no-fault kind of system. But the idea is, again, the public shouldn't bear the costs caused by your products. You, the manufacturer of the products, the ones that are in position to either prevent the damage or certainly tell the truth about what the damage is going to be and support measures to mitigate the harm or prepare for the harm, et cetera, where your product has caused states to incur costs, you're liable as a matter of law. That's very well established law at the federal level. The new wrinkle here is the states are borrowing from the federal Superfund law and using it and enacting it as state law and applying it to climate change. Again, I'll admit this is a expansion of the Superfund theory of liability into a very complex area of both law and fact and science, right, with climate change. And again, until we have seen how these cases work out and are litigated and get to the jury and see what juries do with the evidence, we don't know whether the states are actually going to succeed in these cases. There's a long way to go on that and lots of obstacles and arguments to overcome for the states to recover. But the basic theory that the states are pursuing here is well understood. It's been well established at federal law, and now we'll see if it can apply to climate change damage.
Coming up next, we'll tell you about similar cases that the Supreme Court has turned away. You're listening to Bloomberg. I've been talking to Professor Pat Parenteau of the Vermont Law and Graduate School. In January, didn't the Supreme Court turn down an attempt by a group of 19 Republican-led states to block lawsuits by 5 Democratic states against oil and gas companies trying to hold them responsible for climate change?
Yes, they did, in 2 different cases, one from Alabama, one from Ohio. And these were original actions that the red states were trying to get the Supreme Court to take these cases and block all of these different lawsuits by the states. And you're right, the Supreme Court denied the review of those cases or denied invoking their original jurisdiction without an opinion, by the way. The Supreme Court also rejected a request for review in the Honolulu case, which probably was a better vehicle, frankly. If the Supreme Court was going to take a case that would look at these constitutional issues of preemption, Commerce Clause, et cetera, it would have been the Honolulu case. It took the Supreme Court 3 or 4 different conferences, including requesting the views of the Solicitor General, before the Supreme Court finally decided not to take that case, which is clearly a green light for the cases to proceed and for the Supreme Court, for the moment at least, to stay its hand and wait to see how these cases sort of percolate up and back to the Supreme Court.
So, we've talked before about how the Trump administration is targeting climate policy, and the EPA Administrator Lee Zeldin has said his agency is going to overturn a finding under the Clean Air Act that greenhouse gases endanger public health and welfare.
Oh, yeah. So you talk about irony, or maybe even the other word, hypocrisy. Here's the way this works. The Department of Justice, in these cases challenging the state lawsuits, is saying that those state cases are preempted by the Clean Air Act because it regulates all of these greenhouse gas emissions. And yet their client, Administrator Zeldin, has said, I am embarked on a process to repeal the endangerment finding, which is the foundation for all of the regulation under the Clean Air Act. That doesn't add up, does it? If the Clean Air Act did preempt these cases, and by the way, I don't think it does, but if it did, according to the Justice Department's argument, then what the heck is Administrator Zeldin doing, taking away EPA's authority to actually regulate the emissions? Makes no sense.
And what has the Interior Secretary, Doug Burgum, been up to?
Well, he's the head of this task force, and I forget the exact name of it, but it's an energy, basically, task force. It's the idea of an entity that's going to restore America's energy dominance. So his role is to facilitate the development of fossil fuels, fast-tracking permits and licenses and leases and all of that. So he's coordinating across the federal government to make sure that Trump's policy of accelerating the development of just fossil fuel. He's also opposing renewable energy. They've canceled permits for offshore wind development on the East Coast. They've withdrawn areas that were designated for wind development in the Gulf, et cetera. So they're doing two things at once, promoting fast-track fossil fuel development while inhibiting and prohibiting and taking money away from renewable energy. So that's Burgum's role in all of this. Facilitate fossil, block renewable.
Is this like a broader attack than just by the Trump administration? Because House Republicans passed a measure that would thwart California rules that ban the sale of new gas cars by 2035, joined by 35 Democrats. I mean, what's that about?
Yeah, that's what's called the California waiver. Under the Clean Air Act, California has independent authority to set more stringent vehicle emission standards and even relatedly fuel economy standards. California has done that ever since 1970 when the Clean Air Act was passed. And of course, California at that time had some of the worst air quality in the country. Now other places like Houston and Denver compete with that, but still there's a lot of serious air quality problems. So California has this unique authority, which they've used and has been upheld by various administrations over time for over 40 years. It's given us some of the most innovative clean car technologies. Think catalytic converters, which eliminated lead poisoning in the air, which was killing people and causing serious brain injuries to children and so on. It gave us the hybrid vehicle technology because it was California who told Japan and other countries producing automobiles that they wanted to sell in California that they were going to have to meet their low-emission vehicle regulations more stringent than what EPA was requiring. And that's what led Toyota to begin to develop the now hybrid technologies that we see being developed all over the world and so forth. So the California waiver has ensured that the United States has been a leader in clean car technologies, right? Now, of course, the House Republicans have used what's called the Congressional Review Act process, which requires just a simple majority in both houses of Congress to pass a resolution, which, of course, then the president would sign, and Trump certainly will sign this one. And so that's what's just happened in the House, is they used this CRA process to revoke the California waiver. Here's the tricky thing about it. When it gets to the Senate, there's a rule which requires the Senate parliamentarian to certify that a provision in a fiscal bill, a money bill, which is what the House is working on, the reconciliation bill, a budget bill, right? So in the Senate, the parliamentarian has ruled you can't include revocation of the California waiver in the Senate because it's not germane to the budget bill. This is called the Byrd rule, by the way, after Senator Byrd. But the Republicans in the Senate are now trying to mount a supermajority to overturn the parliamentarians' rule on that. So it's a long-winded, unfortunately, conversation, but we don't know whether the revocation of the California waiver will pass the Senate. It looks like it might, and that would be a very unfortunate thing for not only for climate change regulation, but just for public health in general, because the more that you eliminate emissions from vehicles, volatile organic compounds, and other toxic air pollutants, the better people's health are that are breathing all of that automotive pollution in the big cities of America, right? So it isn't just climate that they're impacting with revoking the California waiver. They're really damaging public health across the country.
So we'll see whether these Justice Department lawsuits get very far or whether they're dismissed at an early stage. President Donald Trump's first appellate court nominee will be Tennessee state litigator Whitney Herndorfer to the U.S. Court of Appeals for the Sixth Circuit. Herndorfer directs the Strategic Litigation Unit for the Tennessee Attorney General's office. She defended Tennessee's near-total ban on abortions in instances when life-threatening pregnancy complications arise, and challenged a Biden-era rule prohibiting discrimination against transgender students under Title IX. Joining me is an expert in the judiciary, Carl Tobias, a professor at the University of Richmond School of Law. Carl, tell us about Herndorfer and whose seat she's taking.
She will take a vacancy created by a Democratic appointee named Jane Stranch, and it was the seat that Carla Campbell was nominated for by Biden, but was one of the four people at the appellate level who did not receive a final confirmation vote because of the deal that was struck in November by Democrats and Republicans. And so that's the seat that Herndorfer will be nominated to. The president announced the nomination after 11 p.m. on Thursday and on Truth Social, and there's nothing on the White House website yet, so her name has not gone to the Senate. Her background is very strong. She was a clerk for Justice Brett Kavanaugh when he was on the D.C. Circuit, Justice Samuel Alito on the Supreme Court, and then Justice Amy Coney Barrett on the Supreme Court. She also worked at Williams & Connolly, which is a highly respected Washington law firm. And recently, she has been the director of strategic litigation in the Office of Tennessee Attorney General Jonathan Skrmetti, and litigated some cases involving abortion and transgender people. And she also is quite young, I think 37 or 38.
Yeah, I was going to say, if she just recently clerked for Supreme Court justices, she doesn't have that much real-world experience.
That's right, but she has the experience, of course, at Williams & Connolly, and the experience with the Tennessee Attorney General's office. And so has done, I think, some significant appellate-type work, which is what she'll be doing on the Sixth Circuit.
Is she one of the youngest people to be nominated for an appellate court?
Yes. The only one I can remember is Allison Rushing on the Fourth Circuit, and I believe she was 36 and was working for a D.C. firm at the time. And so she was, I think, the youngest appellate nominee from the first term of Trump.
So this continues his first administration's practice of nominating young judges who also have shown allegiance to conservative causes?
Well, I think that's right. I mean, that's what she's doing in the Tennessee Attorney General's office, to be sure. At Williams-Conley, that's the firm that's representing Perkins Coie in battling the executive order. So they deserve a lot of credit for that representation because it's not popular in the White House. In any event, I think that it is true in the Tennessee Attorney General's office, being the director of strategic litigation, she would be and has been involved in, I think, abortion litigation as well as litigation involving transgender people. That's all valuable experience. And I think that she eventually would be chief judge of the Sixth Circuit, if she stays there. But I think the notion is to have people who are quite strong in the conservative legal movement. She looks more like a Federalist Society type pick from Trump 1.0, but it's just not clear.
During his first term, he picked a lot of ideological true believers, in conservative causes. Does it appear that she's one of those, or that's where he's going again?
Well, he may, but he has many fewer this time. In terms of appellate vacancies, there are only 6, 3 current and 3 future. But she certainly has been involved in those cases I described. But it's hard to type her as in an ideologue. I don't think we have enough on her record. I'm sure the Senate Judiciary Committee will scrutinize her closely, and she's likely to be one of the first people, to have a hearing, I would think.
So since this is for a Democratic seat, what was formerly a Democratic seat, what does this mean for the balance on the Sixth Circuit?
There are already more appointees of Republican presidents than there are of Democratic presidents. So to that extent, people are looking at which party appointed the particular person. It adds another Republican, but I don't think it's that close on that court. It won't make a strong difference, but it is an important vacancy. When you only have 6 around the country, that's critical to fill.
So the other appellate openings, are they to fill seats vacated by Republican appointees or Democratic appointees?
Well, that's a good question. Remember, as I said, there were 4 vacancies that had appellate nominees from Biden who were not confirmed as part of that deal. And so one was in Maine, one was in New Jersey, and one was in Delaware. Those are the current vacancies, and that will fall to Trump to fill. And then there are 3 future vacancies, and the Tennessee one is considered a future one. Hermendorfer will fill that. And then in Wisconsin, the chief judge is stepping down on the Seventh Circuit. And in California, one of the judges out there on the Ninth Circuit is stepping down. So that's what we have. The future ones will be later this year.
And the future ones are Republican seats?
Yes, were Republican appointees. As I remember, both, I think, George W. Bush appointees.
Does it appear like the Democratic judges are going to try to hold on and not retire during his term?
That's for them to decide. It's hard to say, but they have not been doing so and didn't even do so much during the Biden years. But I think there are probably more Republican appointees who are eligible under the rule of 80, 65 years old and 15 years of service. But very few of them so far have indicated they're going to take senior status. So we'll see. But there is time, depending on what happens with the midterms. If Democrats were to come back into office, that opportunity would to easily confirm them might go away. And so my guess is that that'll be a high priority for the Trump administration to fill all those appellate vacancies before the end of 2022.
And what about the lower federal courts, the district courts?
You've got 60 vacancies if you count current and future. I think the most important thing is that the vast majority of them are in red states. And so I think that Trump will do exactly what he did in 1.0, and that is try to fill every one of the ones in red states, and then turn to the blue states and emphasize the 6 appellate first, and then go to the 45 or more district ones and try to fill those. And only when he has to and has exhausted the red state ones, I think, will he name ones that are blue state ones with 2 Democratic senators. So I think that's the way it'll go. And Biden did something very similar during his time. He filled the blue state ones. And the other interesting statistic is in terms of emergencies, out of 22 emergencies, 21 are at the district level are in red states. And so those really need to be filled.
In the first administration, it was sort of orchestrated by the Federalist Society, and it went off, almost without a hitch. Are the same people in charge this second time around?
That's less clear. I think Leonard Leo, who was the executive vice president of that group, was the outside advisor for the president, and I think did tender a whole number of names of people who then were nominated and confirmed. I don't believe that's the case now. There's a new White House counsel, of course, and I think that, from what I can tell, Mike Davis at the Article 3 Project is the outside person who is having some influence. And he wrote an op-ed in Fox News about Hermendorfer just the other day when she was nominated, which was very complimentary of her. And so we'll see. Though she looks more like a Federalist Society type of person, she's worked with them and been on, I think, panels at their convention and that type of thing. So it's not clear yet. But I think Davis and his group have a lot of influence. And there are others as well. And I don't think one nominee tells you a whole lot, because I think her conservative credentials are quite clear, and she's taken on some very difficult and controversial cases in the Tennessee Attorney General's office. So I think that she will make a strong nominee, and again, though, looks more like a Federalist Society person than a MAGA judge, if you will.
Let's turn to concerns over the growing number of federal judges who are facing threats of violence. And they include federal Judge James Boasberg and federal Judge John McConnell, who ruled against the Trump administration. Do you see this as an intimidation campaign against federal judges?
Well, there have been concerns about that in terms of safety for the judges who rule in certain ways, or for their families. And apparently there have been some threats. They've tried to step up the security for judges who have been threatened. But it is a real concern, and members of Congress are concerned, and of course members of the judiciary are concerned. And I think it is getting a lot of attention, both in the judiciary and in Congress. So hopefully that will lessen those kinds of threats. But that's very unfortunate, and hopefully the kind of rhetoric that has been leveled at district judges would be tamped down.
Well, even Justice Ketanji Brown Jackson denounced what she called relentless attacks on the judiciary in a speech last week.
Yes, and she was very strong and clear about that, as have been a number of other judges. For example, Judge Bates on the District of Columbia District Court just the other day made the same arguments, and others have around the country. So there's a lot of concern about that being voiced by judges and members of Congress, and hopefully the rhetoric will cease by way of attacking judges for their ruling.
Thanks, Carl. That's Professor Carl Tobias of the University of Richmond Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.